Good morning. Good morning. Welcome to the Franklin County Board of Commissioners meeting. Today is Wednesday, August 7th, 2024. At this point, I will call the meeting to order, and please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands,
one nation, under God, indivisible, with liberty and justice for all.
Adoption of current agenda.
Mr. Chairman, I'd like to amend the agenda that we have in front of us to add 2 consent items, 1 regular business item, and then pull a presentation. So I'd like to add to the agenda Resolution 2024-0185 as item number 5, also item number 6, 2024-0186. Under regular business, item number 1, our presenter today wasn't able to make an airplane flight, so we need to postpone that. So I'd like to pull that off of today's agenda. And then to add under regular business, Resolution 2024-0187, and add that to regular business.
I second.
We have a motion and a second. All in favor signify by saying aye.
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 Approval of minutes, July 31st, 2024. Any additions or corrections?
Not here.
No corrections.
Approval of warrant registers.
Mr. Chairman, we got 2 vouchers this morning. The first being salary clearing payroll, emergency management payroll. I move that we approve the amount of $1,221,534.66 and note that it has been reviewed by 2 members of the auditor's office.
Second.
We have a motion and a second. All in favor signify by saying aye.
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 Aye. Motion passes.
Mr. Chairman, I have fund expenditures. I move to approve fund expenditures in the amount of $685,177.41. And again, it has been reviewed by 2 members of the auditor's office.
Second.
We have a motion and a second. All in favor say aye.
Aye.
Aye. Motion passes. Public comment. Is there anyone in the room for public comment? Please come forward, state your name, and you have 3 minutes. Thank you.
Commissioners, on last week's agenda, the Sheriff's Office personnel placed in front of you an ASR reference to budget shortfalls of what we believe to be about $105,000 in medical benefits, or benefits, I should say, and then increased fees from CCOM. We asked for a inter-budget transfer to make up for that gap, knowing that there's going to be that shortfall at the end of the budget cycle if we didn't adjust that. Our staff is trying to follow policy and the practices of the commission and state bars, which is the state auditor's office. The items were pulled from the agenda by Commissioner Bauman, who said that he believed he had a fix for this and that he would put it back on the agenda for today. That apparently didn't happen. It's not on the agenda, but it is a budget shortfall. I know where we're going to head with it come October, November, and we are just simply trying to give you a read ahead of our budgets, where they're going to be at the end of the year. It's something we should be addressing. It's the professional thing to do, is to adjust our budgets throughout the year when they're brought in front of you to say these are shortfalls that we need to address so that our budgets are in line and they're transparent. Thank you.
Thank you. Anyone else in the room for public comment?
Michelle Andrews. Last week, I mentioned pulling a referendum of the taxpayers' money from Benton Franklin Transit because money's sitting there not being used. and we have this extreme priority with the CCOM issue. And so I called the auditor's office, got a 17-page referendum pamphlet that only deals with legislative. This is a local referendum. This is the taxpayers' money. Taxpayers should decide. You do sit on that board. One person I consulted with said, oh, you have to go ask the board. No, I don't. I'm a taxpayer. So I would ask that you would consider putting a referendum on the ballot for November for the taxpayers to decide to move the tax money over to the CCOM. Okay? And I've already called Benton County. I've worked with their county administrator, and their county auditor is helping me with more information because I needed answers quickly. So please explore this and help out your taxpayer. I'm coming to you. Not doing it on my own, but I will continue to work on it and try to get it on that ballot because that's where our money needs to go. Empty buses and all the issues with the Benton Franklin Transit and their big fancy building, I don't even know what it's for. But please make a note that we need that money moved over. And both the Benton and Franklin taxpayers get to decide that, not the board. Thank you.
Mr. Chairman,
Yes.
for 6 years, I've been trying to get the board at Ben Franklin Transit to vote to put it on the ballot for the people to vote on.
Yes,
And
I believe
For 6
this.
years, I've been battled and beaten and bruised, but nobody shows up at the Ben Franklin Transit meetings, which is this Thursday at 6 o'clock, to weigh in on letting the people have a say on this 0.6%.
That decision is made up by the Board of the Transit. It is, but to put it on the ballot, that is the decision of the Board of Ben Franklin Transit. And this board here has 100% promoted the idea that you're asking for every time. And we get voted down. So the need or the ask would be better presented at the Ben Franklin Transit so that the other board members may get on board. Because I agree with you, there is over an abundance of money in their account, and it should be up to the taxpayers.
Yep.
And this board has always voted 100% to put it on the ballot, and we get shot down by the rest of the board.
I believe the taxpayers can ask for their own referendum. I don't think the board gets to say.
Well, I'm just telling you how it works. And it is a it is a majority vote of the board of the Ben Franklin Transit, which I don't agree with either. I think it should be up to the citizens. It's time for it to be reevaluated.
Yes.
So, thank you. And again, as Mr. Didier stated, the Ben Franklin Transit meeting is this Thursday. And I think that would pull a lot more pull, because you already have our support. We're in agreement with you 100%.
So, Mr. Chairman, the Ben Franklin Transit meeting is at 6 o'clock, and it's at the Benton County Commissioners Board room. We've never had anybody in support of putting it back on the ballot. I would love to have a whole bunch of people show up at this meeting. It would be fantastic for people to finally come and participate in favor of reevaluation of this 0.6%. Thank you.
Yep, thank you. Anyone else in the room for public comment? Do we have any callers on the phone?
I do.
You do. You don't? Okay. All righty. If no one else for public comment, we'll move on to the consent agenda.
Mr. Chairman, I move for approval of consent agenda items 1 through 6 as presented.
I'd second with discussion on number 1.
All right, discussion?
Just wondered, I would love to have a better understanding of, with the budget that we are potentially facing, wondering, the question has been brought before us a number of times of whether there will be a hiring freeze, and wondered if that is what the board's thought is on that. Is this something that is something that we should consider, or is this, I believe that this is within the budget, the current budget that we have, and wanted to see what the thought was there.
The chair recognizes Sheriff Jim Raymond.
So this employee's been hired. He was a previous employee of the Sheriff's Office of Corrections, has went and worked in other places and received more training, advanced training in corrections deputies, et cetera, et cetera. And so this is a common practice when you basically bring a lateral over, is to bring them in at mid-step. And this board has voted numerous times to do that because it's financially in the best interest of the county to do so. And secondarily, I would caution putting hiring freezes on corrections because you do have federal decrees that were ordered by a federal judge that dictated the staffing levels, and I don't believe it's going to be in the commissioner's wheelhouse, for lack of better words, to put hiring freezes in corrections under the current circumstances.
Any further discussion?
No, it's just we've done this request, I don't know how many times, in the best interest of saving the taxpayers' money in this county when we do laterals, and it's a standard request.
So if this has already been done, what is it on the agenda for us for today if this is already a completed process?
Because you have to approve the process. That's the legislative action that has to take place with those type of things. So, because in the end, it's a financial amount. There is no impact to the budgets, by the way. The position that Deputy Hill filled was funded at a top step level, and so we're just bringing him in under that top step in the first place. So
He comes back with the prior experience that we won't have to pay to train him.
that's correct. He's been through the Washington State Academy and had worked for, I think it was 4 years before he left. He then went to Florida, has his certifications in corrections in the state of Florida. He's then come back and worked for a period of time with the Pasco Police Department, and now has lateraled and come back. But there'll be another one in front of you here in a couple weeks, because we have a Benton County corrections deputy who wants to lateral over to our sheriff, to the sheriff's office, that we're going to do the same thing. And at the bottom line is, yeah, it saves money, probably $18,000 to $20,000 by hiring laterals when you can. Yes, so her question was, are we at correct staffing? And the answer is yes, we are, by the guidelines of the federal courts.
All right.
With this addition, we're at correct staffing.
So yes, we have people that come and go out of corrections quite often, but currently her question was, are we at correct staffing? And the answer is yes, we are. Today we are.
With this addition.
With this addition. And then we have another hiring that we're looking at for next week that's essentially, it's filled. It's just going through the processes now. So this isn't a request for an additional body or any of those type of things. It's just simply filling a position that has been vacated with a lateral person into that position. And the money's there. There's really no impact.
Well, it is a matter of public safety, so I I'm in favor of the approval, if you're looking for a consensus.
Oh, I with Bauman, I'm a little concerned as to how this can all take place without the approval of the board first. He's hired, he's working, but we haven't approved it, so what happens if we didn't approve it?
So it's not in your power to hire
No,
and handle anything in the sheriff's office. That's within my wheelhouse, and that's the person I chose to hire.
but it's the chain of events that is
Yeah.
taking place,
The only thing that you get to control is the actual financial dollars.
which are already being handed out without our approval.
If they're being handed out without your approval, Commissioner, I wouldn't be here in front of you.
Well, you said he was hired. If he's hired and not getting paid, then we're sort of,
He's getting paid. He's getting paid right now at entry level. And that, I get to decide who gets hired or let go in the
we
sheriff's
understand that,
office.
but we hold the purse strings.
Right.
The purse strings, the money that you pay him. If you've already hired him, how are we paying him without our approval?
Because you've already approved it in the 2024 budget for the position, for the FTE position. This is just simply, we have hired somebody for an open position, and he happens to be a lateral that comes 100% certified and ready to go, and he's actually working right now. And the request is to make a step increase to a 3 from what it is a 1 or whatever. And that's been going on for years. Every time there is an adjustment or out of the norm of the processes, then it's brought to the board to vote yay or nay.
So in simpler terms, you've hired him at an entry level and you just want to compensate him for his experience, is that correct?
You got it, exactly. And the money's there.
Yeah.
Okay, so in the resolution, it should say to a step 3, not at a step 3. That sounds like you're hiring him at a step 3 right now. So it should say approval to move corrections deputy to step 3.
Yeah, that would be a scribbler's error, I guess.
Yeah.
So,
All right.
any further discussion?
No further discussion from me.
Do we have a motion? Do we have a second?
Yes, I motion and Mr. Bauman second.
All right, all in favor of the motion signify by saying aye.
Aye.
Aye, the motion passes of the consent agenda. Moving on to regular business. The
I don't
present,
see Derek in.
so the first presentation has
Mr.
been
Broughton.
postponed, so.
So Derek is actually at I think he's at a conference in Wenatchee or something. So he asked me to fill in. I know we're on for a short plat appeal from the Planning Department's recommendation for approval. So the issue before the board then is whether to uphold the Planning Department's recommendation or to deny that recommendation, or to modify the recommendation. There's also the opportunity the board could remand back to staff for additional findings. However, that would need to be done with some sort of agreement from the applicant, not the appellant, the applicant, because the applicant has certain rights in terms of the timeline that the development needs to be processed within 120 days. And the applicant also has the right to no more than one open record and one closed record hearing. So here we are, and I won't go through every point on the 105-page materials that the board has. This appeal is really about access. The appellant is indicating that the applicant does not have access to their lot. So, and that's really the only issue I've reviewed. So if there's questions about other issues that are outside the scope of the appeal, I would need some time to look at those. But in terms of the access issue, based upon my review on pages 48 through 50 of the packet materials that are, here on the agenda, looks like a prior owner, Tessitore, conveyed the 2 northerly parcels to a MITS. So we're talking about the southern parcel was the applicant's parcel. So Tessitore retained an easement across those 2 northerly parcels and resided in the southern parcel. The southern parcel is the parcel seeking the subdivision approval. So it's currently owned by Mahler, who's the applicant. When the northern parcel was eventually sold to the Mulfords, who's the appellant, the reference to the 50-foot easement was removed from the deed. However, that deed did contain language that the transfer was subject to easements of record. So the prior 50-foot easements under the Tessitore MITS conveyance, including the easement across the Mulfords parcel, would appear to have been easements of record at that time. So in my opinion, the Mulfords took that property subject to a 50-foot easement across their property. So I don't see it as an issue. I know the appellant's here and they have an opportunity to speak on this, but based on my review, I don't see there being an access issue with an easement because it does appear that at one time there was an easement that was removed subject to the easements of record, and this was an easement of record at that time. You also would need, under the statute of frauds, a signature, because this is an interest in land, and easement is an interest, right? An express easement, one written, is an interest in land. You need signatures by both parties to transfer an interest in land, and it does not appear that there's ever a signature from the southern parcel owner when that easement was removed. So that's an additional concern. Otherwise, if I had an easement across my property I didn't like, I could just quit claim the property to myself and remove the easement. I can't do that. I need the person who benefits from the easement to sign off on that interest. So that's about all I have on that. Of course, there are findings that planning department did make. So, and I think because there's an appeal here, I think everything's probably at play. I know the appellant is really challenging the finding that there is adequate access to the lot. I'm trying to see which finding that is, sorry. But if the board is inclined to take action on this to uphold it, I think they would need to just make a motion. I don't see a resolution in the material, so we'd want to make a motion that that they uphold the planning director's decision. And then it would go back. And if there's any other action the board wants to take, it could consider that as well. So I don't know if, I believe under our rules of procedure for a closed record hearing, which this is, it's closed record, so we can't take any testimony that's outside the record. I don't think that's going to be an issue here, just sort of an FYI. What else? Okay, so it's also a quasi-judicial hearing. So if any commissioner has a sort of interest in the land or the development, they would need to announce that and recuse themselves from the proceedings. So with that, I will turn it over to the appellant. I think Ms. Coel's here.
Good morning, Commissioners. My name is
Morning.
Justine Cayley. I represent Dale and Cynthia Mulford. We're here today on our appeal of the short plat. As Mr. Bridges indicated, the main issue is access to the Mahler property. Now, Mr. Bridges indicated that the Mahler property, which is the southernmost out of the three, so there's Mulford, MITS, Mahler. Mr. Bridges indicated that an easement was retained for that third property because he lived there. There is no residence on that property. Mr. Tessitore, the original owner, did not live on that property. In fact, he lived on another property to the west. So that's not an issue here. Also, as Mr. Bridges indicated, the statute of frauds is core to real property issues, specifically with easements. Now, if an easement was retained, it should be in the record as far as not only the Mulford property, but also the MITS property and the Mahler property. That's not here in this record, and that's the core of the Mulford's appeal. The Mulfords have an easement on their land for access now, and as well as utilities. Now, the way that easements work is if there's an easement on the property, it indicates who it is for the benefit of. Here, the property, for the Mulford's property, the easement doesn't indicate specifically if it's for the public or if it's for a specific other parcel. So when we have that issue, what Washington case law directs us to do is to look at surrounding parcels to see, well, what type of grant was provided when that property was sold. If you look at the Mahler property, there is nothing in the deed for the Mahler property, which is at issue here today, that specifically provides that it has retained an easement over not only the Mulford property, but also the Mitts property. Without that retention in the actual record that's signed by the parties that were exchanging properties, they don't have a legal easement of record. They don't just get to use an easement because one exists on someone's property unless it's either specifically dedicated to them, which is called a easement that is appurtenant to land because it's specifically tied from one parcel to another, or easement at gross, which is for the public at large. Here, the language for the specific easement that's at issue is not dedicated to the public. It has no language that it says who it is specifically for, and Washington case law does not favor easements to the public unless it's specifically provided for and signed off by the property owner, which we don't have here. So we're left with an easement that is appurtenant to land, so we have to look at exactly what it is tied to. The only property that has an easement that is retained over the Mulford's property is the Mitts property. And we can see that by the Mitts property with their language for their legal description that says together with an easement over, and then it has the legal description of the easement over the Mulford's property. Here, the Mahlers don't have that. They have no easement of record. They don't have an easement that is dedicated to the public for their specific use. And based on the record of the properties, they don't have an easement of record and they don't have legal access to their property. And they can't now come before the board and say, well, I have legal access because there's an easement on this property, but not the Mitts property. Don't worry about that. The underlying issue here is there is no easement of record. Now, the Mahlers can access their property through their surrounding properties, but I don't know if there's a road. I don't know if they have some type of configuration. I know that they own a bunch of property around there, but at issue here today is they do not have legal access over the Mulford property, and as indicated in our appeal, the Mulfords have allowed them permission. They've given them permission to use the road, but they don't have legal access to it. And that's the fundamental issue here today. So we're asking that the commissioners deny the short plat and allow the parties to figure out whether or not they have the ability to get an easement by negotiation, which Mr. Mahler already attempted to do, which we included in our record before the commission, that Mr. Mahler knows that he doesn't have legal access and has attempted to get not only the Mulford, but also the Mitts property, which is the second property, to sign off on an access easement for them. Mr. Mahler knows that he doesn't have legal access, and the underlying issue here is just that. Now, if the board approves the short plat, what's necessarily going to happen is a LUPA petition, and then the parties are going to have to argue in court about whether or not he has legal access. As well, if Mr. Mahler chooses to do some sort of development in the future and build properties out there, additional residences, I don't know what his intentions are. I haven't spoken to him about that, obviously. However, the easement at issue, even if he does have an easement, it can't be expanded for additional parties. It can only be for that specific property. Again, Washington case law disfavors easements being expanded beyond their initial use and what the parties' intentions were at the beginning. So if Mr. Mahler wants to develop the property, even if it is determined that he has an easement, he's going to have a difficult time convincing the courts that he's allowed to expand that easement for additional residences out there, if that is in fact what he intends to do. And I'm happy to answer any questions if that's allowed, or if you have any questions for me.
It's good.
Mr. Chairman?
Yes, the chair recognizes Commissioner Baumann.
You referenced that when the property changed hands, that an easement was not retained. I'm unfamiliar with that. I'm unfamiliar with that kind of language in regards to an easement. If an easement is no longer attached to a piece of property, it has to be abandoned or specifically taken out. It's not a retained thing. So I guess I'm not familiar with that.
I think we're talking potentially about two different issues, Commissioner Baumann. So the problem is there is an easement on the Mulford property, and we have to determine who it is for the benefit of. Now, the Mitts property in their legal description provides that here's their legal description, this land in this section, et cetera, together with an easement over. And then it describes the Mulford property.
And that's potentially with a different surveyor at a different time using their own unique language. So that part, I don't know how that carries any relevance with this, because they weren't recorded at the same time, so I'm not sure what that has relevance to.
The relevance is, Mr. Baumann, that the Mitts property has an easement over the Mulford property. So that's how easements get transferred in property records, is my legal description of my property. So in this situation, the Mitts property, their legal description of what they own is their actual property, which is the middle property, tract 2, and they have an easement over the Mulford property. So if they didn't have that language in their legal description that says, I have an easement over this property, then they don't have an easement over that property. Now, if an easement on the Mulford property had said this is for the public at large, it wouldn't matter what the legal description said for the surrounding properties, because it's for the public at large. So it doesn't need to be specifically provided for in the legal description of the underlying property. Here, that's the core of the issue. The Mitts property has the ability to use that easement because they were legally conveyed the same by the person who sold them that property, that said, I'm going to sell you this property, plus I'm going to sell you the right for this easement over the Mulford property. The Mahler property doesn't have that. The Mahler property just says, I'm selling you this property. And we can see that by the record, because the Mahler property legal description does not have any language about an easement.
But that easement language was there previous to the Mahlers purchasing it, and it was not abandoned by anybody. So that appears to me to be an issue with maybe the title company, and one of the reasons why you would do insurance when property changes hands. I don't believe it's required, but it's often, it's certainly a best practice is to have title insurance so that if something like this were to be missed. So the easement was there, but is no longer there, and as Mr. Briggs indicated, there was no relinquishment of that easement. So it was I suppose, an inadvertent mistake, but it was there, and now it's not, and it was never relinquished properly. So it was a mistake in the transfer of ownership.
No, Mr. Baumann. So if an easement exists on someone's property, so on the Mulford's property, they have an easement. Just because an easement exists doesn't mean that anyone
I recognize
can
that.
use that.
I recognize that.
So the problem is who can use it is inherently tied to either the language of the easement through the public, which we don't have here, so then we have to look to the surrounding properties. Just because the Mulfords have an easement doesn't automatically mean that the surrounding properties get to use it. So the underlying issue is the Mahler property has never had language that says they can use this easement. They can't relinquish something that they never had access to, and that's the problem. They've never had any language in their title record or through their deeds that say, I grant to you, the Mahlers, the right to use this easement over Mitts and over Mulford. That's the problem here. They've never had that. So there's nothing to relinquish if they don't have that. And tying back to the statute of frauds, there has to be something in the record that's signed off by the property owners that indicates that. And we don't have that here.
So what would be your response to why the easement was there in the past with a previous ownership group and it's not there today? So why is that the case? Because there was no relinquishment as far as I understand.
I don't think that there's not an argument that the easement doesn't exist. The easement exists. The argument is that it's not for the benefit of Mahler.
What is it for the benefit of?
The Mitts property. So
Why would it be on the Mahler's property? Why does their property previously have that easement attached to it?
it doesn't, Your Honor, or Mr. Baumann. I apologize. I'm used to court. I'll call you Your Honor if you want that.
Thanks.
Mr. Baumann, so the issue is the Mahler property hasn't had the easement. The easement doesn't extend, it might extend to the Mahler property, but the Mahler property has never had access to it. So the way that the property record has changed hands, there is an easement from the Mulford property down to the Mitts property. The Mitts property has a specific grant to use the easement over the Mulford property to get to Fur Road. The Mahler property doesn't have that. They never have.
So does the Mahler property have access across the middle parcel?
I don't know. There's no easement of record also for Mahler to have access over Mitts. I don't know if they've signed anything with the Mitts to have access since the short plat was applied for, but based on the record that I have reviewed, there is nothing for the Mahler property over, as far as an easement of record over Mitts or over Mulford to Fur Road.
No more questions at the moment.
Wow, that's,
I have, Mr. Chairman,
yes.
so in Washington state law, and I'm asking this to Jeff, if somebody buys a piece of property, there's a law here in our state that they cannot be landlocked, correct?
There could be, so easements, sort of backing up a little bit, I think you could buy a landlocked property, but yeah, generally, I think easements can arise in a variety of ways. So right now, we're talking about express easements. So express easements is one of, I think, 4 or maybe even 5 types of easements. So you're describing an implied easement either by necessity or through a common ownership. So sometimes you'll have a common owner who subdivides property, and because they own all the parcels, they don't need to grant themselves an easement.
Right.
And then they mistakenly convey some of that land. And so there's an implied easement for the benefit of the future owners that they can, traverse the land, essentially. And then by necessity would be where you're completely landlocked, and so you have an easement by necessity to cross someone else's land. And that's sort of, it's through a condemnation type of proceeding, like a private condemnation, which is something that I'm not very familiar with, but I know that it's a thing that exists. So that's about as far as, it's kind of similar to eminent domain by a city. So you'd be on the hook for compensation for the owner. But again, here, because we're talking about an express easement, another way of thinking about an express easement is it's a contract. So it's a conveyance and an interest in land. And so the goal in any conveyance and an interest in land, or any contract for that matter, is to determine the what the understanding of the parties was and what the intent of everyone was in making the conveyance. And so here again, you've got the southern parcel, you've got the 2 northern parcels. I agree it's not a model of clarity, but they're initially, when Tessitore divided the land, that person created an easement. I agree, it doesn't say what parcels it benefits. It's just across the northerly 2 parcels. But that strongly implies that it was for the benefit of the southern parcel, because I don't know why you would have that conveyance across the 2 northern ones down to the southern, and who else would it benefit? There's no other parcels in that vicinity. So I think kind of looking at what the intent of the grantor was, that was my assessment, but again, it's just my assessment. I understand, there's differences of opinion on it.
Well, I'm familiar with this, and I knew Hank Tessitore, this is how you
Tessitore,
pronounce Tessitore. And there is also a tower up there. They got to have an easement to get up to the tower. I believe there's some other utilities that are up there that they go up there quite often. And so I'm just wondering why we're trying to shut off the ability for a landowner to use this road for a new landowner to possibly build, I guess. I don't know what they're going to do. They're going to build a house up there, or what? Is that what the plan is, for a house to be built up there?
I don't know, Mr. Didier. I do not know if it's one house or if it's going to be subdivided into a development up there. That I do not know.
Okay.
My mic's off. Did you have more you wanted to state on the record?
As far as the easement on the Mulfords, I do not know if the Mitts property has an easement across it. That I do not know. So the Mulfords property does have an easement for the benefit of the Mitts property. I do not know if the Mitts property, which is the center one, has an easement along its side. It would make sense if it had an easement for utilities, because there is a home out there, but I do not know if it has the access easement as well over that property.
I believe the Mitts property is the furthest south, up against the hill, is it not?
I don't know if there's a hill, so bear with me, I do
Well,
apologize.
there's a
But
hill.
from Fur Road, it goes Mulford, Mitts, which is the other home, and then it's the Muller property. So I'm assuming, based on the topography, that that would be the southernmost home.
Okay.
There is currently an easement. Does it specifically say who the easement is for?
The easement across the Mulford property does not provide in its language who it is specifically for, which Washington courts have disfavor reading conditions into an easement unless they're specifically provided for. So in this instance, the argument that the easement across the Mulford property is for the public at large fails under Washington case law because there isn't a specific dedication in the language of the easement for the public. The only parcel that has anything of record in their legal description or otherwise that provides that they are entitled to use that easement across the Mulford property is the Mitts property.
How long has this gravel driveway been used? Do we have any idea?
I know it's been used for a long time, but that's just anecdotally from the planning director.
I do not know the exact answer. I could confer with my clients who are also here today, just for the record.
But you did state in your letter that it was done with the permission of the landowners.
Correct. The Mulfords have allowed the Mr. Mahler's company to use the road to access the same, which in our appeal, we have indicated that there are a lot of issues with that permission, and whether or not that will be continued is to be determined given the amount of accidents that have happened on that road and the property damage that the Mulfords have had to deal with from the actions of Mr. Mahler and his agents. I don't know if it was Mr. Mahler personally, but the people who are associated with his operations up on the property.
But at one point, they did give him permission to use the easement.
That's my understanding, is that they've provided permission, which does not create, in property, we learn bundle of sticks. Jeff knows this is nightmare. First day of property law, but you get a bundle of sticks for property, and each stick has a different type of either ownership interest or use associated with it. What the Mulfords have granted to the Mahlers essentially is a license to use the property, which is a permission, which is not recorded with the land, it does not run with the land, and can be revoked at any time as far as permission goes. So to the extent that there's an argument that they've been using it adversely, that also fails because the Mulfords have allowed this to happen. So there's not an adverse possession issue, there's not a prescriptive easement issue from my review of the facts. And the issue is simply we've been allowing permission, which does not grant them the right forever to use the easement, unless so granted in writing with the statute of frauds and of record.
Is time of the essence on this?
Again, under the Local Project Review Act, we have 120 days from when the application is deemed complete to fully process it. And so, yes,
And
It is.
when is that?
I don't know off the top of my head when preliminary approval was granted. Mr. Mahler may be here also. He would have an opportunity to speak. I don't know if Ms. Coel is, sorry, your name, I'm
It's
butchering
Kaylee. It looks,
Kaylee.
just don't think about the way it's spelled, just.
Yeah. Kaylee, sorry.
I have a letter, Mr. Bridges, that indicates, that's from the planning department of May 10th, 2024, but I don't know if that is the approval. It's just this letter is to inform you that has been granted preliminary approval with these conditions, et cetera, which could be the date, but could not be the
Right.
date.
And again, I would caution the board in remanding this back because of the applicant's right to have one closed record, one open record hearing. If we remand it back and then it comes back to us, we're really having two closed record hearings on it, which I don't like that.
So Derek's asking for consensus on,
Yes, so again, what the board is doing today is, it is either approving the findings of the planning director, which was to approve the short plat. He has those findings listed there, which is in our subdivision code, or we can deny it, or we can modify his approval with conditions. I would offer that with the caveat that I think it's problematic to condition short plat approval on obtaining a private easement. So I think there's case law on that.
So,
I apologize, I didn't mean to cut anyone off. If we did a modification as a condition rather than requiring a private easement, which I agree with Mr. Bridges is problematic based on Washington case law, the other condition could be that there needs to be either a court determination that there's legal access, or that the parties need to determine that either through a declaratory action or a quiet title action, which are the two legal actions as far as if you want a quiet title to something, saying I've used it for X, Y, and Z, or you can go before the court, the Superior Court, and say, here's the record, Your Honor, we want you to declare whether or not we have legal access.
so if that conditional approval, if we believe it was had on May 10th, we would be approaching right now the 90-day mark. Am I accurate on my counting the calendar? Would be 3 days from that.
Right.
So
So we have one more month.
So my question, I guess, is I would like to, after hearing today, I would like to study this a little bit further, and I just would like to know that that is not going to adversely affect.
We could not close the hearing, I suppose, and postpone it, but I think we'd want to hear from Mr. Mahler first, the applicant, before making any determination,
I would love to hear from the applicant.
unless you have anything else.
I don't, I would like to reserve, but that's not, I don't know if that's how this works, that's how court works, so.
Yeah, I think it looks pretty loose in terms of our procedural rules for these, so I think we probably would love to hear back from both after we've heard.
Perfect. Thank you so much for your time this morning.
Thank you.
Yes, my name's Caleb Mahler, applicant, I guess. So I have 3 parcels to the south of the Mitzes and Mulfords. 3 current parcels, 2 of which are actively farmed. The third, which was a 9-acre parcel that is recorded as a building lot as per Franklin County currently. So to retain the farm ground as farm ground, I was going to sell the 9-acre parcel because of the taxes on it and do a boundary line adjustment because we have a main line to access farm ground above to the south of that property. Looking to do a boundary line adjustment, create a 3-acre lot, sell it, so I'm not creating any more parcels. There's 3 parcels currently. There'll be 3 parcels when we're done, just shrinking the one to maintain the most agriculture farm ground as possible. The deeds record, I actually have 3 easements through Mitz's property, 50 feet on the west side of their property, 80 feet on the east side of their property, and a 6-foot easement running north and south with a main line underneath that goes through their property to go up the hill to the south, apologize. So the whole reason I guess we're here even through the short plat process is because we have an unconforming lot of the 9-acre parcel due to current zoning laws of 20 acres or less in agriculture. So the whole reason that it's a short plat is just, it's a boundary line adjustment is all we're after. The access easement to these parcels is tied to the parcel, not to my name. That's why it didn't get transferred. I've contacted the title company, and they say that it's irrelevant. Record of survey doesn't have the statement that the original deed has. The deed is where the easements are recorded on. The record of survey does not have to have that on it as long as it's on the deed. It goes with the property, the parcel numbers. We're not creating any more parcels, 3 parcels. I do not want a development. The only reason I'm selling is because the taxes on that property is ridiculous. So I'm just trying to get out from underneath a building lot that it's cheatgrass, sagebrush ground I can't even farm. So, I guess that's all I have. I guess you guys have any
And you
questions?
were verbally given permission to have an easement through there?
When I bought the property, from Tessitore, the estate of Tessitore after Henry had passed away, they, in the purchase and sale agreement, all easements from Tessitore Living Trust transferred to Mahler in the, purchase of the property.
And you've been using that easement for how long?
I purchased the property in 2011. And there is a cell tower, an internet tower, and the cell tower one I know is recorded as that easement, it's just on my property, one of my contracts up there. So yes.
All right, thank you. And Jeff, Derek is just asking for a consensus on the approval of the short plat.
That's correct. I would just like to clarify for the record, I don't recall seeing any reference to a third parcel and 3 easements over the Mitz property. I just saw the westerly easement. Were those provided as part of the record?
As
Yeah.
for the 3 parcels, it's because of the way he owned a bunch of property and divided it up, things were not really clear which parcels, other than the 2 are specified. The third one is not real clear on but it is the only access to those parcels is through that.
Was the information regarding the 3 easements, was that provided to the planning department?
The 2 easements.
The 2 easements?
For
Okay.
for the 2 parcels, or actually, yes, all 3 of them are on I want to say page 49.
Okay. Want to make sure we're not considering something outside the record. But yes, Commissioner, to answer your question, we are either approving, modifying, or denying the planning director's recommendation of approval.
How long has that driveway been in use?
I do not know the answer to that. Pre-existing to the cell tower, which I believe went in 94. And that road is used to access farm ground as well that is on that parcel.
If it is Derek's question as far as for consensus on approval, yeah, he has my consensus to, I don't know what the other 2 commissioners want to do, but
Is there anything else you'd like to add, Mr. Mueller?
No, I don't believe so.
Okay.
So-
Does Ms. Coel have anything she'd like to add? I know she referenced maybe wanting
Mr.
to-
Chairman, before Mr. Mueller leaves.
Yes.
Jeff,
Sure.
you know, I live out there too, and so we're facing a lot of houses being built out there. And I understand your property tax issue. Is there any way that he could take that out of being a separate parcel and include everything up in there if he wants to continue farming to get that all one parcel? Could he remove those building parcels so that his tax could be lowered? Because I'm gonna tell you right now, you put another house up there, you don't know who's moving in, it could be more headaches for you. That's all I'm saying. The more houses that are out there, the more people that are gonna be upset with what we're doing, airplanes in the air flying. Just farming, that's all we're doing. And I think maybe it might be of your interest to put everything back to one parcel. My son's looking at that doing on his property because his taxes went through the roof. And that may be what you want to try to do, is maybe just get it back to farm ground instead of a building lot and pay a whole lot less in taxes. Don't create a bigger headache for yourself. Just a thought.
Right. Right. I think it's kind of, I guess, we have our code says one thing, and then we have the state law, the state subdivision code as well.
Yeah.
And so we kind of use that as a guideline and look at our code insofar as it complies with state law. So really what we're looking at here is whether there's adequate provisions for health, safety, and general welfare, water, what is it? Provisions for disposal of sanitary waste. And what I'm getting at there is these are provisions for those things. So right now, we don't know whether, I assume he can dig a well there, but we don't know that for sure, right? It's subject to him establishing that. Same is true with septic. It could be the case that the whole place is sand and there's not suitable soils for septic. So we're sort of conditioning approval of these subdivisions on a future approval by another department. And it may be somewhat analogous to the access issue, right? I think we can maybe condition the approval on Mr. Mahler working out access issues, so it's more clear. But we just have to, I think, not do so in a way that requires him to obtain an easement. If
So
he
this
doesn't have
closed
one.
record hearing is still open. That's why we're engaged in this, correct? We have not closed it.
We never
Well,
opened
it's,
it.
it's a closed record hearing, so it
But-
means
but
it's
we
based
never-
on the record.
Yeah, but we never closed the hearing.
We
So
haven't
it's-
closed it, no.
Right, so, and we still have a month to go, right? According to Mr.
Right.
Bauman's. So we're under the gun, but we're not desperate to make a decision today.
We don't have to, right? We have 120 days
Okay,
max.
And is that accurate to say that that letter of conditional approval is the start time of that 120 days?
No, it's from when the application is deemed complete. So
So we actually don't have any idea when that date is right now.
I don't. Do you know when your application was deemed complete?
I do not know.
It's from when the permit's accepted at the counter, they review it, they say, looks complete. That's when the 120 days is triggered. So,
Do you know approximately how long ago that would have been before the May 10th? Any idea?
I do not remember. It's drug on longer than we were hoping and expecting, so I don't remember what the application date was.
Well, Mr. Chairman, with the information we have before us today, I believe that we need to move forward with affirming what the Planning Commission said.
Is there a consensus on approval of the short plat?
With me, yes.
Okay.
well, the majority of the board has moved with it. As unity, I will go along with my two commissioners.
I believe we have the consensus that he's looking for.
right, so I think procedurally, we'd want a motion then, and I think a formal vote, right?
Thank you.
Well, it looks like he's just asking for consensus, the way I read it.
Do we need to close the closed record hearing and make a motion on the?
Unless we want to hear from the appellant again, I think she wanted to.
Yes, I'm in favor of that.
Thank you, Commissioners. Just very briefly, Mr. Mahler's property that is at issue here does not have an easement of record over the Mulford property. If he represents to this board that he has easements over the Mitts property, I don't have any reason to disagree with that. However, there is no evidence before the board that he has an easement of record tied to his deeds or anything in writing that has been recorded with the county, which means he does not have legal access until a court orders it otherwise. That's it. Thank you.
Thank you. It is a recommendation of the planning director, Derek Branton, to,
Is to approve, or to, I guess, uphold his recommendation. So we would need, sorry, let me pull our code. I just had it up and I was looking at a different section. We're in 1480-060, procedure for closed record appeal. I'm in subsection F. So the appeal body, so the board, shall determine whether there is substantial evidence in the record to support the decision of the hearing body. The appeal body may affirm, modify, or reverse the decision of the hearing body. So that's where we're at. I think there'd need to be a motion to affirm, modify, or reverse the decision.
So at this point, I will entertain a motion.
Mr. Chairman,
Yes.
do we need to close the closed record hearing first before we make a motion?
Yes, yes.
So at this point, I will close the open hearing,
Closed
It's
record.
closed record
closed
hearing.
record hearing. All right, so at this point, I will close the closed record hearing and entertain a motion.
One moment here, I'm writing out a motion. So, Mr. Chairman, I would move to affirm the decision of the planning director on his approval of short plat 2024-06.
We have a motion. Do we have a second?
I second.
Motion and a second. All in favor signify by saying aye.
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 Aye. Motion passes. Moving on, Resolution 2024-0187, Procurement Services Cooperating Purchase Agreement presented by Jeff Briggs.
Okay, so, good morning again, board. We have the board has the authority to, under the Interlocal Cooperation Act, to enter into these cooperative purchasing agreements. What we get out of this is we can piggyback off of other agencies' agreements who are members of this cooperative purchasing arrangement. Members are nationwide, so as long as those other agencies, those public agencies follow public bidding laws that comply with our own, which we would need to review if it was outside the state, then we can piggyback on those agreements. And this can save us money and time because it's an exception to the procurement laws. So in other words, we would not need to, for something that constitutes a public works, we would not need to comply with all the notice and soliciting bids and doing an RFP. We could just use that contract. If we felt it was in our best interest. We're not required to, obviously. So there's not really a much downside, if any, to entering into this. I didn't note that a lot of other jurisdictions are already Omnia partners, as well as Franklin County was an Omnia partner years ago. Jennifer might know the exact dates.
2004.
2004. So this is not new to us, it's just we haven't renewed it in quite some time, so we would need to, if the board is so inclined, enter into this agreement once again so we can, utilize the benefits of membership. And there's no cost
That's
to it
correct.
also.
Mr. Chairman?
Yes, Commissioner.
So my timeline here isn't very, I am not very associated with this timeline. Was this when we had the biggest fraud in the Washington State history occur? Or was this with any association with this?
It wouldn't have been, no. The only reason that we're renewing, it doesn't have anything to do with
What happened in Franklin
correct.
County?
The only reason that we're renewing this interlocal agreement is because they don't have records that go back to 2004, any newer agreements.
Okay.
And so while we've been members of this, they're just requiring us to sign a new agreement, which I think that we should probably look at all of our agreements every 3 years, if that. And this is good for all of us and good to renew something that we can benefit from, especially in the economy that we're in, so.
So can someone tell me what the acronym OMNIA stands for?
Omnia,
I tried
do
to
not.
find it, and
It's Omnia Partners is what the website is, so.
What kind of savings do you think this would save our county by re-enrolling and being part of it?
Currently I'm looking at one of our contracts that's coming up, and it's over $1,000 per building per quarter. And so it ends up being almost $5,000 every 3 months that we're saving if we benefit from one of their contracts that they have available, that they've gone national for.
Thank you.
And that's only one, so.
Is there any dollar value attached to this, or this could go up to as much as was needed?
There is no, go ahead.
I think answer, so any contracts would still need to be approved by the board. This isn't granting anyone authority to sign contracts on behalf of the board. This is just giving us a different mechanism to obtain contracts that doesn't require the formal RFP process. So when there are Omnia contracts that are of interest, we would need to present those to the board for review and approval.
And essentially what this is in a nutshell is other agencies have negotiated the pricing and contract terms that we could then accept if we so choose.
Right, just
No
benefiting.
requirement to, just benefiting from the efforts of another agency having already done the footwork.
Correct. And we're obviously doing the homework on their pricing and what they're using it for and looking at it for ourselves.
Thank you.
All right, any further questions? If not, I will entertain a motion.
Mr. Chairman, I would move for approval of Resolution 2024-0187 as presented.
I second.
It's been a motion and a second. All in favor, say aye.
Aye.
Aye. Motion passes. Moving on to Commissioner Administrator updates. Commissioner Baumann.
Thank you, Mr. Chairman. Had a productive SAP meeting last week. Appreciated all the agencies that were involved there and the just really learning and understanding that better. Appreciate everybody that, one thing that I ask the people there, that if they would help me learn the process, I'm working hard, doing lots of reading, but just ask them if they would help me learn that process, and quite a number of them said that they would be happy to help me as they've seen, technicalities or specific things that they would be happy to provide input, so I really appreciate everybody that did that. Also got to participate last week, along with the Commissioner Delvin from Benton County, in one of the graduates from the Juvenile Drug Court. And just really appreciate, as over the last number of months, I've been learning more about that process, and appreciate the invitation to participate in that graduation, and congratulations to that graduate as they were able to complete it. And it was really a lot of the facilitators there in that court system, including the commissioner, expressed the appreciation for that young person and the progress that they've made, and their plan is to help others in similar situations. So congratulations to that person there. Also attended the rebranding and the 50-year anniversary of the Lourdes Behavioral Center. It was really special seeing all of the community come out to that event. It was very well attended, and it was hot as could be that night. They did have a tent and provided a very nice meal and lots of information to the community about some history and the people that have been integral along the way. There was a lot of the doctors that have been a part of that over time, retired, that came and helped with that celebration. So congratulations on 50 years of that facility and the people serving our community. Had lots of meetings with the different offices around this courthouse as I'm learning about the upcoming budgeting that we're doing, WASAC Zoom meeting, Pasco City Council meeting, meetings with the City of Pasco and Lords about the 23-hour sobering center, and the request that we've received that from the advisory board, the Mental Health Advisory Board, about standing up a 23-hour sobering center. Appreciate everybody that's been working on that and all their efforts. Number of meetings and phone calls also about substance abuse and mental health in our community. Spent some time here downtown, all hours of the day and well into the night, just witnessing and looking and seeing what's going on. And that's my report, Mr. Chair. Thank you.
Thank you. Commissioner Didier.
No meetings last week, pretty light week, but a lot of phone calls on, of course, our election. And one gentleman, Mr. Osmond, that lives out here, is 93 years old, and he kept asking why he wasn't going to get to vote for Commissioner Mullen. And of course, he was asking about Randy instead of Rocky, so I told him it was Rocky that's the commissioner, not Randy. But I think we all know Mr. Floyd Osmond. Him and his wife still live out there, and he's very concerned that he's not going to get to vote in the general for the commissioners. And I had to explain to him as what transpired and why we're in this is because he was asking me, well, don't they represent the whole county? And I said, yes. And he said, well, the whole county should get to vote for him in the general. And I said, I agree. But it's out of our hands. It's been a ruling. So Benton County Commissioner called me yesterday, had their administrator on there about our bi-county meeting next Monday. They just did not want to have OPD on the agenda. So can't talk to my commissioners outside the meeting, so I just want to let them know that there's only going to be two, I think you got the sheet on it, there's only 2 items that we have to have them specifically listed as what we're talking about. Not that we can't talk about it, but they're anxiously awaiting for us, and it's on the agenda today, or for our, it's been already approved, hiring Eric Johnson and getting him in touch with Jared McPherson over there and start working together as counties again with an administrator so we can get things moving ahead. Wes Harris, talked to Wes Harris. He's wanting to know where we're at on the HVAC, on putting it out for bids again on the arena side. He's very curious as to what's going on there. We need to get that moving along so we can get the bid process done correctly. And there's people that wanted to put a bid in, so wanted to know about that. And then also the parking lot, about our public works possibly looking into that. And I said we already talked about that last meeting, and that we're looking into that and seeing what the feasibility of that taking place is. And then I'd like to know where we're at on our AG ruling on our improper funds, actually giving a pay increase to former commissioners. Where are we at on this? And my reasoning is this: the AG is only going to give us an opinion. It's still up to us to do something. And I think we need to get this, and I want to know if my fellow commissioners agree with me, we need to get this in front of a judge, because the way I read it, the law was broken. And we need to make sure this never happens again in Franklin County. And the only way we're going to make sure that doesn't happen again is we got to get something going on this and get a judge to rule on it. And that's what the AG is just going to give us an opinion, and then it's up to us anyway. So why don't we move forward on it? That's the end of my report.
So last week I had the Greater Columbia Behavioral Health meeting, also the Southeast Washington Aging and Long-Term Care. The topic was dementia, and so that there is help available out there, or they can answer any questions if you have any questions on dementia. We can direct those to the Aging and Long-Term Care. They can answer those for you. Just want to say that with the added amount of public records requests that we have, that we should be looking at possibly putting on a part-time position to help handle with the increase of public records requests. And also want to welcome Eric Johnson as the new interim county administrator. He'll be starting August 13th, and we're all looking forward to having him come in and help us. Took some phone calls on the emergency phone tax that's going to be on the ballot. Their question was if they could simply use the UHF with new repeaters. So I will just put that out there. By county meeting next Monday, yeah. Just want to say the Hapo horse stalls went, the sale is complete. Looks like they raised about $250,000 prior to fees and expenses, so the county should come out with a couple $100,000 on that. Also received a letter from the United States Department of Interior on Bureau of Indian Affairs, and they have given their approval on the travel plaza with the Colville tribe. This is only on the gas station travel plaza because there will be no gaming on that, at that particular portion of the location. So that did come in. And that concludes my report for this week. Any administrative office business?
I do have one thing for the board. I spoke with DES, Department of Enterprise Services, and Commerce regarding the $1.5 million solar grant for the Hapo Center. So if the board is so inclined, we can put that on the agenda next week for more discussion.
Yeah, I'm in favor of
Okay.
that. Yep. All right, public comment. Is there anyone in the room for public comment? If so, come to the mic. You have 3 minutes. Please state your name.
Michelle Andrews. I'm going to go back to talking about resolving issues within this county. We need to have you go, and Matt, go and talk to the sheriff, give your information, resolve the contention over our county and what's going on. Taxpayers have the right to know. They do. They can be very forgiving. They can see the intent of people trying to manage and bring people together. Issues with the safety of our dome are paramount. We need to have this done. We need to have it resolved. We pay for all of it. And it's hurting the fabric of our community when governing isn't going well. And I personally have been part of that. The RCW is for a civil service commission. I'm just going to read it to you. I've chosen to forgive quite a lot. RCW 4114-200 states, cooperation and aid by other county officers and employees. All officers and employees of each county shall aid in all proper ways in carrying out the provisions of this chapter. Such rules and regulations as may from time to time be prescribed by the commission, this is talking about the Civil Service Commission, and afford the commission, its members, employees, all reasonable facilities and assistance in the inspection of books, papers, documents, accounts, applying, or in any way appertaining in any and all offices, placing, position, and employments subject to civil service, and also shall produce such books, papers, documents, and accounts, and attend and testify whenever required to do by the commission or any commissioner. I was a commissioner. I had a plan to get us through to an independent. I was not heard. not serviced, I was not helped. In fact, a member of this body tried to appoint our chief examiner, which is our purview only. Now that guy's gone, and now you have, one of the things you have with this approving of a position is that you're now closer, without having a county administrator, to making more decisions that you're seriously only supposed to be a check and balance in. You're getting really close to having some serious legal issues. And I would prefer, take $25,000 out of your income, that's $75,000 towards a county administrator, and
3 minutes is up, thank you. Is there anyone else in the room for public comment? Or do we have any callers on the phone? All right, hearing none. Jeff, is there any need for executive session today?
We do have a need under potential litigation, RCW 4230-110-1I. It should be 15 minutes.
All right. So at this point, and who would you ask to be present?
The board and legal counsel. The clerk of the board is also welcome to attend.
So at this point, we will go into executive session under RCW code. Jeff, what was it again?
4230-110-1I, potential litigation.
All right, thank you. So the time is 10:22, and we'll be going into executive session. Thank you. The time is 10:39. We've come out of an executive session. Is there any more business for the good of the county? Hearing none, this meeting is adjourned.
We don't have a workshop today.
No workshop today.
I would suggest next week